Now, we just want the ones that are going to argue on this case. We don't want the others on the...
I think we give an introductory speech.
For the call. Mm-hmm.
Hear ye, hear ye, hear ye. The United States Court of Appeals for the 10th Circuit is now in session. All those having business before this honorable court may now draw near and they will be heard. God save the United States and this honorable court.
Good morning, everyone. We had intended
Good morning, Your Honors.
Good morning, Your Honors.
in person in Denver, but they intervened, and here we are on Zoom, and grateful for the technology of these. We have 6 cases for decision today, 3 of which will be publicly argued, and our plan would be to proceed through those 3 without a break, but it's possible that there'll be a break. Stay tuned and monitor to make sure where we are. And with that, the first case that we have for argument is United States versus Mullins, and it is docket 247003. Counsel, Ms. Donnelly, when you're ready to make your argument, we'll be pleased to hear it.
Thank you, Your Honors. Good morning. My name is Katayun Donnelly, and I represent the appellant, Mr. Mullins, in this case. Mr. Mullins has raised 3 questions of law in this appeal. First, did the trial court violate the Jury Act? Second, did the trial court err in its legal conclusion that the physical presence of the prosecutor is necessary to trigger the protections of Rule 410A4 of Rules of Federal Evidence? And the third question is, did the trial court err in its legal conclusion that release of correspondence between former defense counsel and the government from the defendant's client file is subject to non-disclosure under the Federal Rules of Criminal Procedure 16? As a part of that question, there is the issue of whether, as a matter of law, the government could ever meet the good cause requirement where the client file, at the very least, could be released for the eyes of the current attorney. As to the first question, the Jury Act, we had very interesting facts in this case. Before the jury selection was it started in this case, the attorney and the criminal defendant noticed the absence of any members of the Indian American population, which is about the population of 140,000 in the Eastern District of Oklahoma. And interestingly enough, by contrast, they noticed that there's 7 members of the citizens from the small town that the alleged crime had occurred in Ida, Oklahoma, out of the 49 jury members. And when they compared the two, the absence of any members of the Indian American community or the Black community, by contrast.
Counsel, did you file an affidavit?
Yes, Your Honor. So within 7 days of that discovery, the defense counsel filed a written motion. The issue was raised orally that same day, but that is not significant because the statute 1867 and 1861 that are the subject of this argument, the requirement for the affidavit is met when it is filed with the court within 7 days of the discovery.
Are you saying you did file an affidavit, a sworn affidavit, setting forth the reasons for your allegations?
Correct, Your Honor. The trial counsel, I was not the trial counsel if you're asking me personally, but the trial counsel did file an affidavit that was attached to the written motion.
You're sure it was a sworn statement?
The way that you're asking me, Your Honor, I'm going to doubt myself, so I'm going to have to look back, and I will, of course, get back to the court if I have made a mistake. My understanding has been that there was no dispute that the argument that the government has raised was the timeliness. it was not that the other requirements were not met. If I'm mistaken, I'm sure that Mr. Flanagan is going to correct me. But assuming that I am correct, that the requirements were met in the written filing that the defense counsel submitted to the court, then the only issue, the main issue here is that under the Jury Act, my client had a right to a hearing. The act is very specific. As long as you have the showing of the grounds, it triggers the requirement for a hearing. So you can have the testimony from the people involved with the jury commissioner to come and testify. You can present additional evidence. And as you see in the record, the trial counsel actually was very specific about the use of a statistician. And then they said that we want to bring in our expert to show why these numbers are impossible. But they were flat out thrown out, and there was never a hearing held. And that is what we're asking for. That was a reversible error. The Supreme Court of the United States in test has been very specific. This court in Lawson has followed test that when a timely request has been made following the requirements of the act, that the granting of that hearing is automatic. There is no discretion in it.
Well, it's your obligation, isn't it, counsel, when you filed the motion to strictly comply, not just with the timeliness issue, which the court did find it untimely, but with the substantive requirements of the act, which I believe requires counsel to file a factual statement, an affidavit that actually swears that there's a factual basis that shows the substantial failure to comply. Here, as I understand it, your affidavit simply recited that they had visually observed that they believed there weren't any Native Americans or African Americans on the panel, but it didn't cite any statistical evidence or any other real substantive information about the number of, for instance, African Americans and Native Americans in comparison to the number in the county or anything else. It was just the visual observations, wasn't it?
Your Honor, the visual observation was during the day that the jury was being selected, but all those numbers were submitted in the written.
What numbers were submitted in the initial motion?
Yes, Your Honor. So
what was submitted?
They attached the table that we have included in our briefing that had all the numbers. So I had, the numbers that I took that included in my briefing, they all came from the affidavit in the record, and the record citation is there.
What numbers are you referring to?
So I'm going to refer the court to page 10 of the opening brief. So
okay,
page 10, and that takes you to volume 1. I don't have that in front of me,
but yeah.
That takes you to volume 1. I apologize. Am I interrupting you?
What did these numbers show is what I'm asking you.
So they showed exactly what I was describing to the court, that you have the population in Eastern District of Oklahoma is over 700,000 people. About 140,000 of them Native American, yet you had the allegation was that there was 0 Native American out of the 140,000. And in comparison, you had 17,000 people in Idaho, Oklahoma. And out of that 17,000, there were 7 people present from the venue where the crime had occurred. That was a part of the affidavit submitted. And that is the triggering point for the application of the act, the strict application and the requirement for a hearing. As to the second issue, Your Honors, I would like to start by the fact that, we have a disagreement as to the standard of review. This court in Browning in 2001 decided not to reach that question as to what the standard of review is. We are asking the court to address it now. We have addressed that in our briefing. We are asking the court to apply the de novo review. The government is asking for the harmless error analysis. Aside from the clear error analysis, as to the merits of the question, again, we have this bizarre interpretation of 410, even though we have at least we have the Second Circuit in Cerna, we have the Eighth Circuit in Macaulay, and I cite that 715 F3D 1119 at 1125 and 26. Both of the circuits that have reached this question, there has never been an issue as long as you have the participation and involvement of the prosecution. The argument here that because the prosecutor was in a separate car following my client is one of the most interesting arguments I've seen in case law. There is no question. You
mentioned Cerna. I mean, Cerna, it seems to be the case you're relying on, the Second Circuit case, but that case wasn't anything like this. And the fact that there, the prosecutor made specific statements, as I'm recalling, to the defendant that his statements would not be used against him. And then this DEA agent followed up with questions. And the prosecutor specifically authorized the agent who was asking questions in Cerna to discern the sincerity of the defendant. So he gave him authority, essentially. There's just no facts like that in this case.
Well, Your Honor, the key point is not whether the promise was made. 410 does not require a promise. What it requires is that you are in active negotiations, that there's a participation of the prosecution, you are engaged in the plea negotiation, and as a result of that plea negotiation process, you are providing a statement. And that's what happened. So it's absolutely irrelevant that in Cerna there was a specific promise. That's not a requirement of 410. And as I mentioned, I'm also citing...
Well, the rule itself says that the statements are made during plea discussions with an attorney for the prosecuting authority. Plea discussions with. That certainly, at least in some cases, has seemed to indicate that if the prosecutor needs to be present, the statements are made with that prosecutor present, or at the very least, there's something like there is in Cerna where there's some connection between the prosecutor's negotiations and the agent who follows up. And that's what I'm saying seems to be lacking here.
And that would be, Your Honor, that is my question as to how could it be lacking? You have literally the prosecutor in the car following the defendant. How could there be any lacking of a connection when you have two cars following each other, following the defendant who's making the statement as to where to go? And
did a defendant take the authorities to a body without plea negotiations?
I apologize, Your Honor, I couldn't hear you.
Well, could a defendant in a given case simply have remorse and say, I'm going to take you to the body without there having been plea negotiations?
If they're out of their mind in a criminal prosecution, perhaps, Your Honor, but which defendant represented by counsel, which counsel would tell the defendant, please go ahead and do this, not get anything in exchange? A
counsel who's trying to avoid the death penalty.
Exactly. So that is exactly, Your Honor, you just answered the question, which is this was in exchange to dropping the death penalty. This was a part of a plea negotiation to drop the death penalty. Otherwise, which counsel in their right mind could tell the criminal defendant, you go ahead and deliver what the prosecution is asking you and not get anything in exchange? That would have been an effective assistance of counsel per se. And as to the harmfulness, again, we have cited the case law from the Supreme Court is very clear that this could never be a harmless error because of the fact that in Harrison, the Supreme Court explains, this forced the defendant, Mr. Mullins, to testify in the second trial. If the trial court had not suppressed this information, would have granted a motion to suppress this information, Mr. Mullins would not have been forced to testify. He was forced, and therefore, this court should reverse the decision not to suppress.
Well, you argue, I think, in your brief that the discovery issue is de novo. Do you have any authority to support that statement?
Yes, Your Honor. So this is not necessarily the discovery issue. The de novo, if I'm understanding the question correctly, the de novo versus clear error was addressed in Browning, and the court in Browning actually acknowledged that there are different circuits, different courts that have addressed this and have gone in different ways. So the authority is there. At least based on Browning itself, the decision of the Eighth Circuit says that as a mixed question of law and fact, we ordinarily review de novo a district court's determination that a statement was given in the course of a plea negotiation. And that's what we're asking the court to do. If I may, I would like to reserve the remainder of my time.
Very well.
Thank you.
Mr. Flanagan.
May it please the court, Patrick Flanagan on behalf of the United States. The United States is asking that the judgment and sentence against Mr. Mullins be affirmed. The court's orders regarding the Jury Selection and Service Act, the Rule 410A4 analysis, and the court's order on the communications with Mr. Gifford and not Mr. Adams were all correct within the court's authority, and the judgment and conviction against Mr. Mullins in this case should not be overturned. Going first to the defense's argument regarding what I'm going to call the Jury Act rather than the Jury Selection and Service Act in this argument, the defendant didn't comply with the requirements of 28 USC 1867. What that requires is prior to the venire or within 7 days of when they could have discovered, whichever is earlier, a motion has to be accompanied by a sworn statement. In this case, it was not. Prior to the venire, there was no motion and sworn statement received by the defendant pursuant to the Jury Act. It was only after venire, 6 days, 3 days after the verdict was returned, that a purported sworn statement was entered with a renewed motion. Regarding defense counsel.
So there was an initial motion that was not supported with an affidavit. Is that right?
Yes, there was an initial oral objection on the day of jury selection.
Yes, an oral motion. Yeah, I guess I was getting confused about that. There was no support for that one.
Correct, Your Honor.
And would it have been timely? It's not being challenged on appeal, right?
Not to my read of defense's argument was that the objection restarted the clock for them, and that's just not the case under the law. It's not one motion. It has to be made and accompanied before the venire.
Okay.
And the reason for that is a good one, because the Jury Act doesn't attack individual juries. It attacks the fundamental process in a district by which juries are picked. Test was very specific in that case, before the venire, after grand jury, but before jury selection, Test actually filed a motion supported by a sworn statement in which he claimed that the process by which the grand jury was picked and the process by which the petit jury would be picked excluded disproportionate numbers of people with Spanish surnames, students, and African Americans. And attached to that was an affidavit stating facts that had been disclosed in testimony in another case. It was after that filing and compliance with the procedure that the U.S. Supreme Court said, okay, you're entitled to this evidentiary hearing. That posture simply isn't present here. The requirements of the Jury Act set the time as no later than venire, and the defendant in this case was later than venire when they raised that. Notwithstanding the untimeliness, Judge Goodwin reviewed the motion, made findings, determined that the failure wasn't substantial, and the defendant hadn't established relief. He could have denied the motion and the oral objection prior to venire by its non-compliance, by not containing a sworn statement, but he didn't get to it on that grounds. He judged on the defendant's oral statements of, there are too many people from Ada and we don't recognize any Native Americans. It wasn't, and even when they did make the written motion and sworn statement, it wasn't that there weren't Native Americans, it's that his argument was, well, we didn't recognize them. That simply isn't sufficient. And the court's order on the Jury Act should be affirmed. A failure is substantial when it frustrates one of the three principles underlying the act. First, the random selection of jurors. 2, the culling of the jury from a fair cross-section of the community. And 3, determination of disqualification, exemptions, and exclusions based on objective criteria. The district court did that with its order, even after finding it was untimely. So there were multiple grounds on which the defendant's motion was denied, and those were correct. Moving on to the analysis of of the defense arguments regarding Federal Rule of Evidence 410A4, defense counsel's laboring under a misapprehension of the facts. There was no evidence introduced and no finding. It was only a 2-car convoy. In fact, the testimony that was presented that wasn't disputed was it was between 10 and 15 cars. So the idea that he's in a trailing car, there's a factual disparity with the testimony. Notwithstanding, the district court didn't actually make a determination because there was a dispute of facts of whether plea negotiations had begun. ADA Ross, or former DA Ross, testified there was not plea negotiation. Former defense attorney Frank Stout testified there was. Rather than resolve who the court found more credible, the court said, even assuming the defendant's version of events is true, these should not have been excluded. 410 is not a constitutional right. It is a right that has been delineated by Congress to encourage plea negotiation. It is very clear on its dictates. Different districts have extended that beyond when there are clear designations of authority by an attorney, but there was no evidence of that here to the law enforcement agents. The defendant led to the body of the victim in this case. So the case law, as the district court evaluated, doesn't apply here. And the defendant's stated belief in his testimony wasn't reasonable. The district court did not err by allowing in the statement that the defendant led police to the body of Rachel Woodall. Additionally, defense counsel has tried to extend the 410A4 prohibition to what they're arguing are fruits of the poisonous tree, and that just hasn't happened in a civilian court. That extends the statutory prohibition on comments far beyond what Congress apprehended, and the civilian courts that have evaluated it have pretty consistently said that it would be for Congress to extend it that far, not the court. This isn't a constitutional argument under 410. It is a statutory construction. The one military court which did construe that actually construed it, in part at least, because a civilian attorney disclosed attorney-client privilege material and that it was the identity of a witness. So I would submit that that's a case of bad facts getting bad law, but in addition, it's a military court with a different version of 410 than what's present here. So the evidence derived, even excluding, assuming for purposes of argument, the defendant was correct that the statements on or about April 21st of 2002 should have been excluded. All the evidence that was derived should have been included under Rule 410A4. And that evidence was substantial, significant. The body, the DNA evidence that was recovered, the shell casings, the opinions of the medical examiner. Even beyond that, the statements the defendant made to Special Agent Craig Overby after his conviction from the state could not fall under Rule 410A4, because at that point, the defendant had already been sentenced, was already facing a sentence, and there is in no way and no evidence that Special Agent Craig Overby was authorized to negotiate a plea deal on a closed case. So that statement would have come in regardless and wasn't covered by this prohibition. And in that statement, the defendant stated that he made the correct moral decision, but a poor legal one, to lead police to the body of the victim in this case. with that leads kind of into the harmless error analysis of the 410 evidence, in that the government submits there was sufficient evidence regardless of whether the April 21st statement of who led police to the body of Rachel Woodall came in, because you had Special Agent Craig Overby, who was able to testify about it and was properly admitted. You had all the physical evidence and the derivatives from finding the body. And notwithstanding, you had all the evidence that preceded finding the body. The evidence in the defendant's trunk, the evidence in the defendant's home, the defendant's possession of the victim's diary in his home, his false exculpatory statements, his minimal injuries, his attempt to conceal his involvement by calling the then boyfriend and mother of the victim, and also the testimony of Miss Chadwick James, who was able to establish by her testimony the defendant repeatedly asking whether the victim's roommate was going to be present. The testimony of the eyewitness that, contrary to the defendant's claim, placed him at the victim's home at 3:30 in the morning on April 20th of 2002. So all of this evidence was in, and the jury would have heard it. So notwithstanding whether there was some error in letting in the April 21st statement that defendant led police to the body of Rachel Woodall, there was sufficient evidence to find him guilty. And that doesn't even discount the testimony the defendant gave. Getting to the defendant's argument on Harrison is different. Harrison involved confessions that were obtained unlawfully. Is a violation of a constitutional right, not like here where there's a statutory construction. So in that instance, there were 3 confessions in the prior trial that were admitted. There was also, I believe, a statement made in opening that the defendant was not going to testify, but after those confessions were admitted, he did in fact testify in that first trial. And when the first trial was overturned, and they went into the second trial, and his testimony was admitted in the second trial, that was found to be error. But again, that involves a different question. That's a constitutional question. And notwithstanding the strength of the evidence in this case, notwithstanding the April 21st statement, would have been sufficient for the lure the defendant to testify as he did. And he asserted self-defense. Although defense counsel didn't address it in her oral argument regarding the question regarding emails by Mr. Gifford, and that did not also CC Mr. Adams, those emails were submitted to the court to review in camera whether the defendant's concerns about what they contained were valid. The court reviewed it and made its determination based on its discretion under Rule 16 that they did not have to be produced to the defendant, that the defendant's, in fact, concerns weren't valid. So it was reviewed in camera, and the district court, as it's authorized to under Rule 16, limited the discovery. That was within its discretion. It did not harm the defendant, and it should not be grounds for overturning the verdict and sentence against the defendant.
The district court said that those communications between the former counsel and the prosecutor didn't belong to this defendant. Do you agree with that?
Your Honor, if it did belong to the defendant, arguably under Rule 16, then they were produced on their creation, and that requiring us to produce it again is a step too far. So notwithstanding,
why is that a step too far? I mean, if there are communications that were between her former counsel and the government, and why is it a step too far to produce them again if she doesn't have access to them?
Well, Your Honor, that we submit the defendant did have access. If they belong to him, his attorney, who was his attorney, has the ability to give it to his new attorney. If there's a dispute between those two, that doesn't involve the government. and notwithstanding the district court.
I guess, yeah, I'm just questioning whether that was really necessarily true, that communications, regardless of whose file they are in, communications between a prosecutor and an attorney, defense counsel don't belong to the defendant, almost as though the defendant's he's not entitled to them, you know.
Well, Your Honor, the district court only spoke to his entitlement under the rules of discovery. The order leaves unaddressed whether he's entitled to him under other means or other requests. It was simply the defendant's motion to compel their production under Rule 16 that order addressed, and the district court was within his discretion to do that. I am down to about 13 seconds at this point. If there are no other questions, I'd yield my time and thank you.
Thank you, counsel. There is some rebuttal time left. Ms. Longley, I believe.
Yes, Your Honors. I would like to start with answering Judge Kelly and Judge Murray's question. The affidavit is volume 1, 612, and then the 605 to 22 and 38 to 42 have that material. The important part about the government's statutory interpretation of 1867A is its complete disregard of the middle sentence. This subsection says in criminal cases, before the voir dire examination begins, or within 7 days after the defendant discovered or could have discovered by the exercise of diligence, the grounds thereafter, they can...
Whichever is earlier. Whichever is earlier?
No, Your Honor. That is the issue.
Okay.
It says, or within 7 days after the defendant discovered or could have discovered by the exercise of diligence. And that is important because if it assumes that if you knew before voir dire, you have to raise it, it ties the point of discovery to the point of raising. But if you discover during the voir dire, which is this case here, then you have 7 days to raise it in writing. And that's exactly what happened here. They discovered during the voir dire, right before the voir dire, the first day of the trial, and they raised it within 7 days. So that was complete compliance, and the government statutory interpretation would completely render this middle clause meaningless. And as to the caravan, whether the caravan...
It does say whichever, it has to raise the jury act challenge before the voir dire examination begins or within 7 days after discovered or could have been discovered, whichever is earlier.
Whichever is earlier. So it doesn't matter because the earliest part was during the voir dire, right? So there was no other point of discovery. The government is not claiming that this was, that the oral motion was the only thing that could have been done on that day. So to say that if you discover it during the voir dire, you shall file a written affidavit that has all this information while you're in the middle of the trial is impractical. So the only way that you can read whichever is earlier is the point of timing as to discovered or could have discovered.
Seems to read pretty clearly. Reads pretty clearly to me, but you're basically just you're twisting that completely around and saying it doesn't mean what it says.
Your Honor, I'm just looking at the practicality of how can a trial...
I'm not talking about the practicality. I'm talking about what the statute clearly says in terms of timeliness.
I appreciate Your Honor's interpretation. That is the submission that we are making to the court. And if I may, as to the caravan, the number of cars in the caravan, I understand that my time is up. If I may finish that, is that it doesn't matter if the caravan of the cars that was following the defendant had 15 cars or 25 cars. The point is that the prosecutor was the last car in that caravan. So they were all following the defendant heading to the body. And it is undisputed that the court found that it believed the defense counsel's count of whether they were in plea negotiation. That is an undisputed piece of this analysis, and the government has not filed a cross appeal of that finding of the court. So that's...
Okay. Counsel, your time has expired, and
Thank you,
I wanted to let you wrap up, but it looked like we were going to keep going there. So
yes, Your Honor. We stand on our arguments on the third, on the briefing on the third argument. Thank you, Your Honors.
Okay, thank you, counsel. The case is submitted, and counsel are excused.
Thank you, Your Honor.
I think I see counsel is required in the next case, which I will call United States versus Williams. It's docket 24-1510. Ms. Johnson, please proceed when you're ready.
Thank you. May it please the court. My name is Gail Johnson, and I represent Kyler Williams in this direct appeal from the denial of his motion to suppress. The question before the court is whether the warrantless search of the vehicle that Mr. Williams was driving can be justified as reasonable under the Fourth Amendment as an allowable protective sweep that was supported by concerns for officer safety. Now, the government bears the burden of showing that this warrantless search was reasonable. And in order to do that in this case, they need to show that the search was supported by reasonable, articulable suspicion of two different prongs. First, that the suspects posed an immediate or present danger to officers or others. And second, that that suspect might gain access to a weapon. Here, the government doesn't get past the first prong because we have a distinction between the person they think is dangerous and the person that they're supposedly protecting themselves from. Namely, the government agrees here that Mr. Williams, who was in custody, handcuffed in a patrol car more than 25 feet away from the vehicle in question, he wasn't posing a threat to officer safety at the time of the protective sweep. So the government's theory here, which the district court adopted, is that the danger was posed by Mr. Williams's girlfriend, Ms. Richardson.
You'll need to unlock your iPhone first.
I apologize, Your Honor. I'm not sure how that came up. I've turned it off. Won't happen again. So the government spends all its time talking about dangerousness with respect to Mr. Williams, but they don't disagree that Mr. Williams didn't pose a danger to the officers at the time of the protective sweep. Now, the notion that simply by dint of the romantic relationship between Mr. Williams and Ms. Richardson herself posed an immediate or present danger to the officers and might gain access to a weapon. That theory, in our view, is based on the exact kind of inchoate suspicions and unparticularized hunches that the Fourth Amendment clearly prohibits. I know the court has read the briefs, but to really quickly summarize the facts, Ms. Richardson had no warrants. She had a valid driver's license. She owned the car. There was no indication that she or Mr. Williams, for that matter, had committed any crime that evening. Again, Mr. Williams was pulled over in a routine traffic stop for failing to signal a left turn. And Ms. Richardson, I think, as is clear from the videos and the officers' reports, was 100% compliant, cooperative, and polite with the officers. So I know the government relies somewhat on these common enterprise cases, such as Dennison and perhaps Faker, and I do want to address that briefly. Those cases involve situations where either one of the individuals in the car was a suspect in a particular crime that had just occurred that evening, or where one of the individuals in the car had made a suspicious furtive gesture, or both of those factors. Neither of those factors are present here. The officers observed no furtive gestures from either Mr. Williams or Ms. Richardson at any time. And there was no suspicion or report that the officers were following up on or any indication whatsoever that either of them had been involved in a crime that had just occurred. So I'd ask the court to reverse the judgment of conviction and remand with directions to grant the motion to suppress, but I'd be happy to answer any questions the court may have. And seeing none, if I may reserve my remaining time for rebuttal. Thank you.
Mr. Gruel, when you were ready.
May it please the court, Bishop Gruel on behalf of the United States. In Mr. Williams' response to our 28J letter about the McGregor decision, he effectively conceded that he himself, that there was reason for the officers to suspect that he himself was armed and dangerous. The only distinction they raise is basically whether that reasonable suspicion could then be attributed to his girlfriend, who would be allowed back in the car. Under the Dennison...
Just how could that happen? How could that suspicion about whether this defendant might have been armed and dangerous if he were in the vehicle, which he wasn't because he was handcuffed, arrested in the squad car, how is it that somehow we're going to just assume that this girlfriend, who is courteous, polite, cooperative, does nothing absolutely out of the ordinary, has her registration papers, owns the vehicle, has a valid driver's license, and is ready to drive the car home, what are we possibly basing an assumption on that there's reasonable suspicion that she is both armed and dangerous at this point?
Because all of those same facts that you raised, Your Honor, were true of Mr. Dennison.
What does that have to do with particularized suspicion about the occupant of the vehicle, which is what is required? What do we have? What do we know about this occupant, which was the girlfriend at this point, to indicate that she was somehow armed and dangerous?
The same thing that we knew about Mr. Dennison in that case. We knew that she had been in this small car in a high crime area late at night. That is what you had for Mr. Dennison. He showed his identification. He owned the car.
We got a lot more for Mr. Dennison. I mean, that's there's all kinds of stuff. He was nervous. He avoided eye contact. He listed the Denver Detention Center as his residence. He admitted he'd been locked up for a organized crime violation. He admitted he was a member of a gang. He had a tattoo on his forehead showing he was a member of the gang. He had 2 active arrest warrants, and he had a history of weapons offenses. What does that have to do with whether his girlfriend was armed and dangerous?
Sorry, I'm not comparing her to Mr. Williams. I'm comparing her.
What else do you have? What else do you have?
I'm trying to compare her to Mr. Dennison in the Dennison case, who was just like Miss Williams, or Mr. Williams' girlfriend.
Okay.
I believe it's a completely different situation,
right.
Isn't it? Really, Dennison, where you have these gentlemen who are parked and where they were parked and the concerns about that. And one of them, they're looking to be in concert in criminal activity. She's a passenger in an automobile that gets pulled over for a blinker violation. If you're saying that Dennison controls this case, then I'm not sure I could agree with that. And I guess I'd ask you this. Do you think that if we were to agree with you in this case, that we would be extending the circumstances in which protective sweeps are allowed in the circuit by a good margin?
No, I think this is narrower than Dennison. In Dennison, what this court relied on was the fact, when you look at the actual analysis where they talk about Ibarra and the rest, and they conclude that Mr. Dennison, that there was reason to do a Michigan v. Long search on him. The 3 things they look at: the fact that he was in this small car, in this high crime area. To the extent there are other facts in there, they didn't rely on those. But if you want to talk about those facts that suggest perhaps there was other criminal activity going on here, likewise with Miss Williams in the car, you have the fact that she is with a person who's an admitted gang member in a gang area where there's rival gangs in high crime area, that she is likely. That
might indicate she has poor judgment, but that doesn't indicate that she's a romantic partner. There's no question. That's what they see her as. She's a girlfriend, whatever the terminology you want to do. But there's no evidence that they were in some kind of joint illegal enterprise. She had a valid driver's license. She owned the car. She produced the registration papers. She's driving with her boyfriend.
And
what is the evidence that the 2 of them were conducting some sort of illegal enterprise together? Because that's what you're talking about with Dennison.
There was not evidence in Dennison that Mr. Dennison had done anything wrong, that he was involved in any criminal activity.
Were they in a romantic partnership in that case?
No, which actually makes the facts here stronger. There was more reason for Mr. Williams' girlfriend to get involved than just some other person who happens to be in the car with Mr. Allen.
So are you arguing for a per se rule then, that if your boyfriend's in a gang and in a certain part of town and doesn't use his blinker, no matter how compliant you are, no matter how polite you are to the officers, no matter that they have flashlights shining in your car as you go through the glove box and find your registration, and they can see every inch of the inside of the car with the flashlight that they can see with the flashlight, that per se, that's good enough. You're the girlfriend, and therefore we're doing a protective sweep, and we're going to pat you down with a male officer, and then we're going to stand you behind the car and handcuff you while we go through your car. That's just the way it is now.
So I'm not arguing for a per se rule. I would actually also, some of those facts are not true. She was not handcuffed until they found the weapon in the vehicle. She was brought to the back of the car, but she's not handcuffed at that point. But what we're arguing for is that this court should continue to follow the facts of Denison, where again, all that they had there that the court relied on was small car, late at night, high crime area. That's and the fact that Mr. Allen there had these outstanding warrants, like Mr. Williams here. This court concluded that it was fair to conclude that because of that situation, small car, late at night, high crime area, it was fair to conclude Mr. Denison being in that vehicle likely knew about Mr. Allen's outstanding warrants, much like it's fair to conclude that, in fact, more fair to conclude that the girlfriend here likely knew about the outstanding warrants and therefore would want to intervene.
What would she want to do? Even if there's some inference that could be made, some reasonable inference that they're somehow in some sort of joint enterprise. I mean, what's happened here is that he has not used his signal on a left turn. So what makes us think that even if they're in some kind of joint enterprise, despite the lack of any evidence on her side of that she's going to turn around and she's going to take her car that she has a registration for with her valid driver's license after being very nice to the officers, and somehow she's going to access the weapon they believe to be there that probably belongs to him, and she's going to use that weapon on these officers? Is that the dangerous aspect of it? Is that the inference that we're making here? Why is she dangerous?
The court here below concluded that was a fair conclusion to reach, and it can do so because there's actually more here again than there was with Mr. Denison. In Denison,
pause on that. Let's get our Denison's facts straight, because looking at the opinion here, what happens is the policeman encounters these two men at approximately 3 a.m. Park. And where are they parked? They're parked at an Englewood, Colorado apartment complex that has had a high incidence of nighttime car theft. You're comparing that to being the girlfriend of someone who doesn't use their blinker?
No, I'm comparing that to being in a car with somebody who is in an area. Mr. Allen, there wasn't even a traffic stop violation there. I'm comparing it to a person who is in a car with somebody who is a gang member in an area where there are tons of rival gangs, where the officers talked about it being an open air drug market, murders, robberies, and all sorts of those things going on.
So per se rule if you're in that area.
What's that?
It's a per se rule, protective sweep if you're in that area and your boyfriend's in a gang. No matter how polite, no matter how compliant.
I think it follows from the facts of Denison, Your Honor, that yet if it's late at night, you're sharing this car with somebody in a high crime area who has these outstanding.
Don't you see in Denison the connection there, that the cops are concerned that they're going to steal cars because cars have been regularly stolen in that area, which is probably why the policeman's even patrolling there. And they're at 3 a.m. in a parked car in that area. You're likening that to driving through a public thoroughfare?
The reason I'm likening it to it is because, again, we're not talking about whether there's PC to search a car here. We're not concerned for Michigan v. Law purposes about whether a crime is occurring. We're concerned about whether there's a danger to the officers. What danger is presented to the officers? Could they be shot on the way, leaving the stop by somebody who's going to get back in the car? And so I don't.
So let me just make sure I understand. What we're supposed to go for is that this woman who's been compliant, who is lawful in all respects with their automobile registration, with everything that's been asked of her, has been compliant, who you cannot ask for a more polite person at a stop like this if you look at the video. And yet her boyfriend is now under arrest. He has active warrants. He's in the back of a patrol car. And despite no firearm being seen with the flashlights, the glove box, obviously there's not one in there because she's rifled through there trying to find her registration with flashlight light shining on it, that she's going to get in her car and she's going to come out firing to save her boyfriend, despite there being multiple cops, police officers. That's what we're supposed to believe.
And Your Honor, with due respect, the facts were the exact same in Dennison, but perhaps worse here. Mr. Dennison was cooperative throughout the process. There was no gun that had been seen. If you read Dennison, the court makes a point of there was no reason to suspect Mr. Dennison based on anything about his behavior, anything in his background. He owned the car. He had an identification.
He was there with the lights off in this car at 3 a.m. with the lights off with this other driver. When asked why they were there, they said, well, we're here waiting for a tow for this other vehicle, not the one we're in, but this other vehicle that's down the way, the two of them. I mean, there were suspicious circumstances in a very high crime area where there'd been a lot of stuff going on. This is not 3 a.m. This is not two men sitting in a car at 3 a.m. in a high crime area who have a story that doesn't necessarily work. This is one individual failing to use his blinker and his romantic partner who's in the car being extremely cooperative, not providing any answers or any information that is inconsistent or is suspicious. And she's ready to drive the car off. In fact, she's told she can drive the car off by at least one officer. And then suddenly they decide they need to do a sweep because she is armed, potentially armed and dangerous. That's what we have here. And this is not like Dennison.
If I may focus on what we have, a woman who is the intimate partner of a person who is a gang member in rival gang territory where crimes are occurring all the time. We have a concern about officer safety as opposed to about whether a crime is actually occurring. Unlike in Dennison, we have a defendant who's actually still there. The court in Dennison assumes that Mr. Allen has in fact been taken away. So there's a greater risk because there are more potential cohorts there. And the additional thing we have here is there is the possibility.
Can you stop and could you answer the question I asked before? What is it that what made her dangerous? What was the potential? What was she going to do? Pull out a gun and start firing at these officers? Is that what they thought? Because she could also have, just even if there was no gun, she could have used her car. A car can be a dangerous weapon. Did they suspect that she was going to run over them because they'd arrested her boyfriend while she sat and observed? I mean, what was the dangerous part of this woman?
The same thing about Mr. Dennison, that he was in a car with somebody who they had reason to suspect he knew had outstanding warrants because it's late at night in a high crime area, small car. That is completely as cooperative, except that here we have a gang member who is in a rival gang area. Reason to believe because of that, he would be armed. It's her car. Reason to believe that she would know what is in her car. And the
Were they
officers,
concerned enough that they had her get out of the car before?
They did have her and they moved her to the back of the trunk, but they did not handcuff her.
No. I mean, during the encounter, before they decide they're going to do a protective sweep.
They had her get out of the car when Mr. Williams got out of the car. So they didn't have all the information that they had when they first stopped them. They don't know about his gang history, that he's just been removed, that he's just gotten out of jail for a violent offense that's involving gang members. They didn't know all of that, so they don't pull them out of the car immediately. But when they pull him out, then they pull her out.
And when they pull him out, they've got it in mind. They're doing the protective sweep.
And by that time, yes, I believe that's when they're going to do the protective sweep.
So they weren't worried enough about her before they decided to do the protective sweep, but then they were worried about her.
They weren't worried about him either, Your Honor, because they didn't have enough information about him. But they did testify once there was the concern about him and the fact that they were going to let her back to the car.
Well, doesn't that seem odd that they've got this guy who they pulled over who immediately they begin to connect as far as gang sort of stuff. And they're not concerned about him enough to get him out of the car, but they are concerned enough about letting her back into her own car to drive away?
Because they didn't have all that information that gives the reasonable suspicion, Your Honor. I mean, they're pulling her out as soon as they're pulling him out, which is the time that they have the reasonable suspicion that there's danger here. And reasonable suspicion is, again, a very low standard. We're concerned about officer safety. We're not worried about PC about a crime. I see I'm out of time. But if the court has any further questions, happy to answer them. This should be controlled by Dennison and McGregor. Thank you.
Thank you. There is rebuttal time, but stick to rebuttal, please. If you plan.
Yes, Your Honor. I do not anticipate using 11 minutes of rebuttal. I just have two very quick rebuttal points to make. The first being there's no concession in my response to the 28J letter on McGregor. I simply focused on the relevant question at hand, which is whether Ms. Richardson posed a danger. And second, there's one very important fact in Dennison that the government continually overlooks, and that is that the passenger there had admitted being involved in a domestic incident, and the police had a police bulletin about a domestic violence crime that had recently occurred. And with that, I will conclude my arguments and reiterate we ask the court to reverse the judgment and remand with directions to grant the motion to suppress. Thank you.
All right. Thank you, counsel, for your arguments. The case is submitted and counsel are excused. Right. The next case that we have for argument today is United States versus Smith. It is docket 24-7081. Ms. Cunningham, we are ready for your argument when you're ready to give it to us. If you can hear me, maybe you can.
Yes, Your Honor. Good morning. Edie Cunningham, on behalf of Appellant Smith, I'd like to try to reserve 3 minutes for rebuttal. The circumstances here strongly supported duress. The co-defendant was a longtime abuser of children and a convicted felon for strangling his ex-wife. Within weeks of meeting Smith, he charmed his way into her life and moved in with her. And he brought guns and knives into her home and threatened grave harm to her and her children if she did not do what he asked.
Well, she had several opportunities to alert the authorities that there was a problem there, and she did not do it at all, ever.
Your Honor.
And what she did was abhorrent. Whether she loved this guy or not, she had the opportunity to alert the authorities that there were bad things going on. Now, explain why she didn't tell anybody about it.
Your Honor, I'd like to discuss the issues that we've raised in the brief. That is an issue for the jury.
My question first.
Well, she didn't, because the co-defendant brought several firearms into the home, a knife called the Heart Ripper. He threatened to kill her and her kids if she didn't do it. He threatened to break her little girl's fingers. He had locks on the tops of the bedroom doors to control her movements. So there were a lot of reasons why she was under an imminent threat. And all of the errors in this case struck right at the heart of her defense. They require reversal either alone or in combination. All were part of the government's improper appeal to the jury to take our word for it. She was a willing participant. I'll first start with the hearsay issue, unless the court would prefer me to start with another issue. The out-of-court statement at issue here was the Tahlequah police officer's statement in the police report that Smith called the police to her home in December of 21 to report a stolen vehicle. That officer did not testify at trial. The witness who testified about it, Agent Kurt, only knew about it because she read about it in a police report. A police report is beyond dispute hearsay under the rules of evidence. And the government weaponized the truth of this purported statement to the police in its closing argument when it argued if Smith was outraged enough to call the police about a stolen vehicle, she could have called the police about her daughters. It was prejudicial. It was used in rebuttal closing argument, which is especially prejudicial, and it went straight to her duress defense. The government never offered any reasonable explanation as to why this was not hearsay, either at trial or on appeal. If there are no questions on that, I will move on to the opinion testimony. We maintain that this error was preserved. The defendant made a preliminary objection before Agent Jackson testified about the videos, that the videos should speak for themselves and there shouldn't be inappropriate comments about them. The district court ruled the witness can testify or comment on evidence that is admitted to the jury. So there wasn't a need to take exception to this ruling. And then again, when the prosecutor first questioned Agent Jackson about Smith's demeanor on the videos, in addition to this preliminary objection, the defense counsel said this is foundation and speculation, which further alerted the court to the problem, but it was overruled. And as this court has said recently in the DA case, counsel need not use magic words or expressly invoke a rule in order to preserve an issue for appeal. But in any event, this was plain error. This testimony about Smith's demeanor in the videos was not helpful to the jury. As noted, the videos were ultimately admitted through Anthony Meaner. They were very short videos, the longest of which was 3 or 4 minutes long. There was absolutely no reason why the agent's opinion about my client's demeanor in the videos was helpful to the jury. The plain language of the rule, Rule 701, makes clear that this was not appropriate testimony. The advisory committee notes to Rule 701 makes clear that when opinion testimony amounts to little more than choosing up sides, it is in violation of the rule. This court in Brooks and Goodman have made it abundantly clear that when a witness is in no better position than the jury to render an opinion, then it is not helpful under 701. And it is hard to think of a better example of opinion testimony that violates Rule 701B. And it was especially bad because it was a form of overview evidence. Overview evidence typically happens in conspiracy cases, but here we had Agent Jackson who was testifying about the videos before they were admitted into evidence. They were admitted into evidence a couple of witnesses later through Anthony Meaner. And what essentially she did, and then Agent Kurt did in her redirect before the videos were published to the jury, was implant the government's theory of the case into the jury's mind before they even had a chance to view the videos. They were spoon feeding the prosecutor's theory to the jury and is, in essence, acting as deputy prosecutors to argue the case when the only proper place to make arguments like that is in closing argument. And it could have had, and likely did have, a very real impact on my client's defense, because if the juries hadn't been poisoned in that way by this improper opinion, they may well have looked at the videos and said, well, Smith is doing everything she can to make sure that this guy is going to be satisfied with what she's doing so that her kids' fingers aren't broken or they're not all killed. But the prosecutor's improper opinion allowed, basically implanted the prosecutor's theory into the jury's mind. And frankly,
what was the jury instructed about duress and what you were required to show?
They were given the standard duress instruction that defendant was under an unlawful and present, imminent, and impending threat, which would induce a well-grounded apprehension of death or serious bodily injury, and she had no reasonable legal alternative to violating the law, and needed to do it to avoid the threatened harm.
Yeah, and these counts, basically the various counts which she was convicted, there were 9 counts that they occurred over a period of 4 days, right? Some of the videos were on Sunday, November 21st, and some of them, I believe, were on Wednesday, November 24th. Thanksgiving was that 2021. I think Thanksgiving was that Thursday. So there was 3 days, at least 3 full days, basically, in between the 2 sets of videos. And yet her claim was that she was under this imminent threat, apparently this entire time, right? I mean, she's got 3 days in there if she was really under this imminent threat to do these horrible, horrible things with her children on Sunday. And we've got video of that, so the jury could observe whether they thought she was under threat, imminent threat. What about Monday and the rest of Sunday and Monday and Tuesday and Wednesday?
Well, Your Honor, if somebody has knives and guns in the home and they're pointing them at you and they're saying, look, if you don't do
what
this.
Evidence was there? What evidence was there that this was happening that entire period? And she had no opportunity to do anything about it legally, to go to law enforcement. What evidence was there about that period? I'm not saying there wasn't evidence that she said, oh, I was under duress, but all we have is some very generalized statements, not about when or how long, if she was held at knife point? Was she held at gunpoint? Was she allowed to leave, not allowed to leave the house? Were the children not allowed to leave? We don't know any of that. We don't know the immediacy of it, the length of it. We don't know whether she had no time in that whole time period or even after to go to
Your Honor, when you're living
the 2 months after she's taken to daycare.
I don't want to interrupt you.
What evidence of a continuing imminent duress do we have, even for the 3-day period that this occurred on?
Well, Your Honor, for one thing, the district court found that there was sufficient evidence of duress and gave the jury the instruction. So I
understand that, but when we're being asked to do, we're going to have to do a prejudice analysis here if you're correct that there were errors.
Well, Your Honor,
potentially more than one error, and I'm just saying the fact that there's an instruction isn't going to be enough for you.
Well, Your Honor, I would just say that if you're living with an abusive monster like my client was, who has guns and knives and a heart ripper knife in the home, who has strangled his ex-wife and basically has
she
lied.
Didn't know that, and she apparently didn't know that. She believed that he was previously a law enforcement officer. She apparently believed some things that he told her at the time. She was not aware of these things.
Well, she was aware he had choked someone, and she was aware that he was threatening her with the guns and the knives. And the fact that she thought he was a prior law
we don't know. We don't know when he threatened her. We don't know how long he threatened her. We don't know if she had an opportunity. We don't know the details.
Well, Your Honor, I would go back to this is a jury issue, and there's certainly enough there for the jury to draw reasonable inferences that she was under an imminent threat. If you are living in a house with an abusive person who is armed, who is telling you that he was a law enforcement officer and he's buddy with law enforcement.
How long was it imminent?
The entire time he was living with her, Your Honor.
These occurred in November. The two days that we have videos that the charges are based on occurred in November, and then there's nothing else. And then he's arrested in January. Do we have any evidence of what kind of threat she was under imminently? that entire time? Is that time period relevant in terms of her not seeking any help, not going to law enforcement, not trying to protect her children?
Well, it's only relevant in the
What
sense
evidence
that,
is there?
well, it's only relevant in the sense that the government used her purported interaction with law enforcement in December, but really the abuse that was proven was in November. So that would be the relevant time period as far as whether she was under a threat. But she was also under a threat not to turn him in. So the circumstances strongly suggest to me that she was under an imminent threat that entire time until he was out of the house. And even then, when she spoke to him on the phone when he was in jail, he told her, "I'm going to get out at arraignment, so I'll be out." So she was still under duress.
And he also told her to get rid of the videos, and she did on her own phone. She deleted those the night before she was arrested.
Well, I think an important point to keep in mind is that, and if you look back at the timing, which I think we've both briefed in our statement of facts, is that she did not wipe her phone until after she requested the interview with Wagner and then Kurt. And they did not seem at all concerned about the threat that she had been under and the duress that she had been under. And it was only after that she tried to, she wanted to cooperate, but the officers did not care about the threats that she was under. And so it was only after that she deleted the phone.
Excuse me.
Sorry.
You're speaking as though duress is a fact. It's established. That's something the jury rejected. She had a shot and they said, "We've looked at all of the evidence. We've heard everything that you wanted to provide to us by argument or otherwise, and no sale."
Well, Your Honor, respectfully, they rejected it in the face of all of these improper tactics that the government used, the improper hearsay, the improper opinion, the improper arguments. So we don't know what they would have done in the absence of those improprieties. And I see my time is over. Thank you.
Okay, thank you, counsel. Ms. Williams.
Good morning, Your Honors. Lisa Williams, representing the United States of America. I am happy to address any of the specific evidentiary issues or the standard of review. It's kind of some issues we believe are plain error. Well, actually, the government's position is that it all should be plain error review, but perhaps some are abuse of discretion. But under either standard of review that this court applies, part of the analysis will either be a harmless error analysis, which the government bears the burden of, or an effect on substantial rights, which the defendant would bear the burden on. But in any event, this court is going to have to step back and say, even if there was error, did it impact, did it affect the outcome of the verdict in this case? And the government's position is it absolutely did not.
Well, before we get there, let's talk about some of these errors, because some of them are problematic for me, at least. I think one that really stands out is the government's prosecutor's closing argument, where she, I'm not sure who the prosecutor was below, says to the jury, methamphetamine users binge, and then they crash. And when they crash, they sleep. And sometimes they sleep for days. And the prosecutor is saying these things so that he can basically minimize the evidence of duress. Essentially, if he was a meth user, then why couldn't she have had days and days where she would not have been under imminent threat because he was crashed out, and so she could have done something. She could have went somewhere. And then you had even more than that. But let me stop with that right there. There were no facts in the record whatsoever, none, to support that he, would binge and then crash and then sleep for days. None. There apparently were facts that he was a meth user. So how was that a proper statement by the prosecutor?
That's correct, Your Honor. The government's argument is that it's a reasonable inference that it could draw. There is no evidence about the effect.
There is none. And is that really a reasonable inference that for days and days he would binge? He's a meth user. That's all we know. It's not a reasonable inference. And then, more than that, the prosecutor instructs the jury, what did Smith do to alert authorities or get help and call for distress during the days that you can think about Mr. Bias's methamphetamine usage? And you can consider whether he was crashed for hours, if not days, at a time. And she did nothing because this is the life she wanted to embrace. This was in the rebuttal closing argument. We took facts that were not even slightly before the jury, and regardless of whether it needed to or not, if the evidence of duress wasn't that great, just shoved them down the jury's throat by, saying, you can consider these facts I'm telling you, even though they're not in the record. I realize the judge is telling you that my statements aren't evidence, but I'm telling you, you can consider all the crashes and the binges, and why didn't she do something during that? That's pretty egregious. And I'd like you to address why, if the only issue is duress, because that's the only issue at this point. We've got video. Nobody's contesting that. Why, with the government shoving it down their throats like that, was that not a problem?
Well, because it's cumulative, Your Honor. That would be the response I would give you. In looking at,
there's nothing cumulative about evidence that's not in the record. Nothing cumulative about telling them to speculate about something that we don't even know happened.
The evidence speaks to, as Your Honor noted, the credibility of the duress defense and whether or not she had opportunities. And there is significant other evidence in the record that speaks to the credibility of the duress defense. So the government believes it's cumulative in that sense. And then, yes, there's no other evidence in the record about methamphetamine users, but for the argument and the purpose underlying that evidence, or the argument that evidence underlines, there's a lot of evidence that also speaks to that argument. So when this court gets to the third prong of plain error, let's assume it was an error and it's plain. And because we do all agree that the closing remarks are operating under plain error review because there was no objection made. So let's assume it was an error and it was plain. This court still has to evaluate whether or not there's a substantial likelihood, but for that remark, there'd be a different verdict. And again, as this court noted during counsel's prior argument a few minutes ago, could have talked to a daycare worker, could have talked to friends or family. I mean, she could have reached out at any other time to other people. So that's where I think the argument really hits the roadblock is and again,
I understand.
I'm not conceding. I'm not conceding it's plain error. But if this court finds that it is.
Can you cite any case where a prosecutor literally made up facts about the defendant and said he was binging for days and crashed, and that this not about the defendant but about the Mr. Smith, and said that this defendant would have had time during those days when that defendant was crashed, and that the jury can consider that? So, I mean, I take it that the government, even though they had presented that argument, which is, what about all this other time that she could have done something? What about the daycare? What about why was this imminent, essentially? They must have been worried about it because they chose in rebuttal to really hit hard on this non-existent evidence.
I would push back that the government was worried about it, Your Honor. And I think that this court sometimes, especially during rebuttal, it's not worrisome, it's frustration. It's that
but it was
so it's not that the government's worried that they're going to lose their case. It's more of a frustration that this woman is a pedophile who sexually abused her 2- and 3-year-old daughter.
I understand all of that. I'm just saying,
she wants the jury to believe that she's under distress.
Right. And there's plenty of ways to challenge that, is my point. And it was done, they challenged it properly. I'm just saying this came in and this was pretty egregious in terms of making up facts. The other thing I want to ask you about is the admission of the lay opinion testimony from both the two agents who weren't there during her video interview, but both were allowed to testify, I believe, before the video even came in. Is that right? About her demeanor on the video the jury hadn't seen yet, right?
Well, and I'm sorry, my understanding is it's her demeanor on the video during the sexual abuse of her daughters.
Well, right.
So it's not an interview. It's not her interview.
Okay. But had they seen that video yet?
The jury had not. No, Your
Right.
Honor.
So I'm sorry, I did get that mixed up. They are allowed to testify about her demeanor on a video that hadn't been admitted yet, and which they weren't present at, and which the jury would see for themselves and make their own judgment. And they did see it. But what possibly would be the basis for allowing two agents to testify about this video, which hadn't even been admitted, and tell the jury what went to the heart of the defendant's duress defense, which is, I don't think she appeared to be under duress in this video that, by the way, you haven't seen yet. And I wasn't there, but I'm going to tell you what I think as an agent. What could possibly be appropriate about that?
Well, I think that 701 does clearly allow that type of lay opinion testimony. And in this case, what's significant...
Well, what does 701 require?
A lay opinion based on the witness's personal observations,
right,
that is helpful to the trier of fact and not expert testimony.
What was personally observed about this? They watched the video just like anybody else.
They did, Your Honor,
and the jury hadn't seen it yet.
And the difference is that they have had prior personal in-person interactions.
But they didn't testify to that, did they? They both made it very clear they were testifying based on what they observed on the video.
Well, I read that in the defendant's reply, and I'd push back a little bit.
I looked at their testimony, and they did talk very specifically, and neither one of them connected what they saw in the video, which the jury hadn't seen yet, let's not forget that, to their work with the witness or interviews with the witness. They talked about what they saw on the video and how they perceived whether she was under duress or not. And the jury hadn't seen the video. So that's what they did.
And I would
let's assume that was error also.
Okay. Then again, assuming that's error, it still does, and if it's plain error, it's the defendant's burden. If it's abuse of discretion.
Well, we did have an objection there to inappropriate comments by the witness commentary on the photos and the videos, and the counsel said those videos speak for themselves. And by the way, the videos hadn't even been admitted yet, so the jury was being told what to think about them before they were admitted.
Yes, I agree. I don't think that was sufficient to preserve a continuing objection to the issue, because
let's assume there was an objection, or we can even assume it's plain error.
That's fine.
Let's assume it was plain error.
So and I'm happy to argue harmless error too, because I think the result is the same. What the evidence is, what the improperly amended evidence is a few sentences of testimony where these officers are saying, she doesn't seem under duress to me. Right? At the end of the day, that's what they're saying. She doesn't seem under duress. She seems like she's a willing participant in the sexual abuse. Because the jury gets to then watch the videos themselves, if the jury wasn't allowed to later see the videos, I think that would have a more concerning effect, because they can't judge the videos themselves. But the jury did get to watch the videos.
They've already been told how to view them before they ever saw them. Yeah.
They're also told in the jury instructions that they're the ultimate deciders of credibility, Your Honor, and we presume that the jury follows the jury instructions. Mm-hmm. So they're told that this is their decision to make. And because of that, they get to see the videos themselves, and they can make their own independent evaluation. The agent's opinion testimony isn't as weighty.
They should have just disregarded it because they could make their own, and they should not assume that these agents knew better than them, probably.
Well, and I don't think there's a single instruction that says the agents that know better than them. Again, there's those two instructions that really say you're the ones that this is your job. This is what you're supposed to do. And you're the ultimate deciders of credibility. And this whole trial is about that, Your Honor. This is a whole trial about, is the defendant's duress claim credible? And the jury's told that's your job. So
Well, that's what 701 is about. Is the whole purpose of 701 is to help to understand, testimony. I mean, to say the idea is, is this person any better suited than the jury to make these determinations? And here, how are they better suited than the jury to make these determinations about a video that obviously they weren't present for, and the jury hasn't even seen? How could they possibly be better suited? And the whole idea is to prevent opinions that tell the jury what to do, essentially, or what decision to reach. And this is what the only decision they had to reach was whether there was duress here. And these two agents told them she was not under duress. And you will see that when you see the video.
Well, they said, in my opinion, right? She's not under duress, which is a fine line to slice. But I do think it's worth noting that it was their opinion. But I would refer the court back to the Chiquito case, which to me is even more egregious than what happened in this case.
Because it's totally different, because the agent was there during the interview.
Well, the agent conducted the
big difference
the video.
to be there. Yeah, and to be present during the interview and be talking about what you observed.
But at the same
there's
time,
a big difference there. Yeah,
I agree. There's a difference, Your Honor. But at the same time, the agent testified she wasn't lying, which I also think is a big difference than what we have in this case. To say a witness isn't lying, I mean, ding, 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 red bells should go off to everybody in the courtroom. This witness is talking about the credibility of another witness, and that's huge. That's what we don't do. But it was fine in Chiquito. And again, I agree that there is no direct loop in the testimony where the agents are basing this opinion on their prior in-person interactions. But that doesn't mean that they didn't have that prior in-person interaction to base their opinion on. And the jury did know that they did have that prior in-person interaction because they talked about the interviews they conducted with the defendant personally. And I think so there, it's not quite to the Chiquito facts, but it's also maybe halfway there. There is some sort of in-person relationship that the agents can base some of their opinion on, instead of just reading off of a cold interview video. But in this case, running out of time, again, the government would come back to, even if there are errors, plain or abuse of discretion, that did not impact the jury's verdict. The evidence was overwhelming, and the lack of evidence regarding her duress is just blatantly obvious on this record. And so even if these didn't exist, the jury still would have convicted, and therefore a reversal is not required. Thank you.
Thank you, counsel.
Your Honors, may I respond very briefly in a minute or less?
Yes. Eric, had you run out of any time for rebuttal?
Yes, I had. I intended to reserve some, but
Okay, take 2 minutes.
Thank you, Your Honors. I believe the prosecutor's tactics here, the links they went to try to implant their theory into the jury's mind that she wasn't under duress, shows that they were in fact worried. And all of the circumstances here suggested duress. My client had never done anything like this before. This was not remotely anything she was into. The co-defendant had been doing this for a long time. The circumstances suggest that he basically ensnared her, moved into her house, and began threatening her to do what she wanted. So I would ask the court to keep that in mind. She was not predisposed to do this. She is not a pedophile. She was made to do this. And the jury should have the opportunity, or another jury should have the opportunity, to view this case without the improper tactics employed by the prosecution.
All right. Thank you both, counsel, for your helpful arguments. The case is submitted and counsel are excused.